Hi, Keat. How are you doing? Hi, Keat. Are you there?
Hi. Yep. Hi, Amira.
Hi.
Yep. Okay, we're okay. We are targeting to go back to office on Monday.
Oh,
Yeah.
fantastic.
Yeah.
Good. Yeah, I'm kind of glad things are slowly getting back, back to what it used to be like. But yeah, exciting times ahead.
Yep. How have you been? Become an expert in virtual webinars, right?
I know, I'm turning into quite a good online MC.
Yeah. Yeah.
Yeah, things have been all right. I've been trying to sort of see when the regulations for cross-border gets a bit looser so I can go back to Singapore and then see my parents before, as soon as I can, actually.
My son teaches in Marlborough College in Iskandar Putri.
Oh, in Johor, okay.
Yeah. So we took him back on Sunday. It was a midterm break. We took him back on Sunday. And we came back the night that interstate travel was lifted.
Oh yes.
Yeah,
Sunday,
we took him back on Sunday. So on Friday, I still had to get a police permit because I was crossing the border, right?
Yeah.
On Sunday, yeah.
Oh my goodness. And yeah, it's midterm break, right? For a week. Even my daughter's on midterm break this week.
Yeah. Then the school, I think, is still online this week. Then next week, I think they will get back to physical because it's a boarding school as well. So there are borders as well.
Yeah. Actually, I think it's good being in boarding because it's very contained as well.
Yeah, kind of like a bubble. Yeah.
True. All right, I think we should get started. Are you ready? I'm going to introduce you. Is everyone else ready? Is everyone else back from getting their coffee?
There is this Anis Duha Ahmad is trying to be admitted.
I know. I think I think it's an internet issue because she's been in and out of the waiting room. I hope it's resolved. Okay. Alternately, she will be able to share the slides with her because it's been happening a lot this morning. So I think she's having unstable internet, unfortunately.
Yeah, it's been happening to my side as well. I hope it does.
Yeah, we had this problem yesterday as well. In the morning, there was some instability with the internet. So we had trouble hearing, and then it was like freezing in and freezing out and freezing in, and it's very frustrating.
Yeah.
Okay, everyone, welcome back. We've got Mr. Phye Keat ready for our next session, which will be titled Trade Secrets and Intellectual Property in Remote Employment. Now, Mr. Phye Keat is very experienced, having been in practice since 1987 and becoming a partner in 1991 of Raja Darryl & Low, and he's currently the firm's managing partner. He's highly respected and highly experienced in competition and intellectual property laws, and has handled a broad spectrum of projects and advisory work relating to competition, JV, manufacturing, telcos, and more. He is one of the founding members of the Malaysian Intellectual Property Association, MIPA, has been the president of MIPA more than once, and is also a past president of the ASEAN Intellectual Property Association. Recently, he has been focusing on competition law as a new niche of his practice. And since the Competition Act came into force about 9 years ago, he's been very active helping various clients become compliant with the Act. So without further ado, I'd like to invite Mr. Phye Keat to take over on his topic on trade secrets and IP in remote employment.
Thank you, Amira. Yeah, good to have all of you on your second day of this amazing conference. And I believe you've been learning a lot and, in fact, sharing your experiences with everyone. I'm not sure there's much to say about the topic in terms of remote. I mean, just because you have remote employment, the IP issues don't change, but it's more a practical issue, and we'll come to that along the way. But I thought it would be good to just refresh ourselves on what is the rights being protected by the company in this particular topic. So we'll go through the IP understanding, and then we will get into this whole area of how trade secrets are protected, and what could happen, and the intersection between protecting your trade secrets and confidential information versus the right of the employee to, in a sense, compete with you after he leaves employment. So that's a topic that a subtopic that will come, I think, quite into the session today, quite seriously surfacing. Yeah. So just get back to IP 101. So IP is, of course, intangible assets, and is of course related to the creation of the mind. We're not talking about tangible or fixed assets which you can touch and feel or own on a piece of paper by way of a land title and so on, with a physical presence or a physical appearance, right? IP is actually not seen. Yeah. That's why it's called intellectual and intangible. So we all use IP. We all create IP in our everyday life. If you wrote your diary or your personal journaling in your own life, that whole thing is protected by copyright because you created that piece of work, a piece of IP. So that's there you have it. And of course, more and more, the world recognizes that a company's value is in its intangible assets more than its tangible. I mean, you don't value Amazon or Grab based on physical assets, right? How many warehouses do they own? How many offices do they have? How many vehicles do they have? No, we value the company based on its intangible, its IP, its manner of working, its computer programs, its know-how, right, that is being protected. So that's how important IP is. And as the country develops, Malaysia being a developing nation, IP will become more and more the key indicator as to whether we are moving successfully in the right direction globally, economically. So now, carrying on this IP 101 sharing, you need to, being property, it is, the meaning of property in the legal sense is that it because it's property, it will be protected. That's the point, right? It's not real property or tangible property, it's intellectual property, but because the law is prepared to give it a identity, so to speak, of being a species of property, then it will be protected, right? And then we therefore have to see, how do you protect it? Just like the land, your landed property is protected based on rights in the National Land Code, a statute. So then we then refer to statutes. Law in Malaysia exists in two forms. What is in the law books by way of statutes passed by Parliament, acts passed by Parliament, or subsidiary legislation passed by a relevant minister. That's statutory, right? But IP's roots actually was in common law. That means the law decided and adjudged by judges in the courts, and someone alleged rights someone alleges his rights or her rights have been infringed by someone else, the defendant, so the plaintiff sues, right? And then the question before the court is, are you referring to a particular statute that protects you and which gives you rights which have been infringed, or are you referring to the textbook law, right? The common law, yeah, not statute book law, but the textbook law. Now, of course, a law textbook can talk about the statutory law as well as the common law, which is a judge-made law. So we have copyright, and then we have designs, patents, and trademarks. So copyright refers to works, karya in Malay, right? Karya cipta, hak cipta would be copyright. And that would be in form of computer programs, would come under literary works. Your artwork would come under artistic works. Your sound recordings, your literary would include, for instance, your in-house documents, right? If you design a particular program to do your HR, or you download or you license, you get a license on a HR program for your payroll, then copyright exists in that program, and you couldn't pass it on to another company to use it free of charge. The licensor, right, the party that licensed you the payroll software, would come after you because you have infringed his copyright by going beyond just your own use as a licensee, right? So copyright protects works, yeah. Industrial designs is a form of protection of artistic works, like the design of a car, design of a mold, design of artifacts being sold. So these are industrial designs, and it requires a registration. Copyright would exist without registration. The registration is voluntary. You could notify the Malaysian IP office of the copyright in the works that you have and register and deposit a copy of that work in the MyPole records. But you don't need it in order to achieve, to get copyright protection. But industrial designs would need registration with the ID office. A patent protects inventions, right? And excuse me, yeah, inventions comes from ideas of solving a technological problem, right? And you create something, you invent something, and then you see whether it's new in the world, and then you go register the patent within your patent office. And then there are treaties like the PCT, the Patent Cooperation Treaty, that allows you to get your patent protected around the world, right? So that's inventions. And then you have trademarks, which of course is your brand, right? Your brand, the name of the company usually is your brand, or otherwise, if you choose not to do so, you could have multi-brands and you could be selling many products, each with their own branded product, and you register the trademark for each of your brands, right? So that would be trademarks. So this is the traditional statutory protected IP, right? Then you have the common law, where you don't really have a statute that protects it because the law already protects it by way of judge-made law. And this is where trade secret and confidential information comes in. There is indirect statutory protection, for example, where the penal code, right? It would be criminal for an employee to commit sabotage or espionage, right? By taking your trade secrets and selling it to a competitor, right? You could actually report to the police, and that would be a criminal offense as well. But if you wanted to stop the recipient of the trade secret from using it and to cause it to deliver it up and to pay you damages, you would need to sue using common law principles, suing the employee who has been the go-between and the recipient of the trade secret, who was part of the, if you like, conspiracy to sabotage your company, right? So that will be, and we'll look at some of these cases later. And then you have passing off. So passing off is actually linked with trademarks. It protects brands, and some trademarks would not be registrable as such because of the formalities required in the Trademarks Act. But you could, because of a notoriety, that means how famous you are in the brand and within your particular market, you are known by people and you can prove that, then you could get a passing off action, right? A right to take a passing off because this other party is trying to pass off as being you or being associated with you. Okay, so that would be passing off rights. And it will apply not only to your brand, but also your get-up, the way you do the packaging of your products, for example, or how you are known by way of just color, right? That's why you see that there is no, for petrol stations, for example, you see very clearly color coding is particularly emphasized because people would begin to identify your brand of product, in this case, a petroleum product, with the color of your station, right? So even colors can be part of get-up that is protected by passing off, right? So this is the refresher, if you like, for you, I guess, on what is intellectual property. And then we, just to recap, these are the various legislation. And when we talk about employees breaching their obligations and using your IP, the company's IP, you probably won't talk about trademarks because that will be registered and the company will be owning it as employer company will be owning the trademark. So that probably won't be an issue. Of course, if an employee left your employment and started up a company and tried to sell a similar competing product and try to use a brand which is sounding like yours, you could take a trademark action, but it's between you and the company, right? Or the business that the employee has started, right? And in a sense, it's like very obvious he's tried to pass off, right? Or tried to infringe your trademark. So that's what we mean by trademark infringement, which wouldn't be so relevant here because we're more concerned about how a employee secretly devolves or divulges your copyright, or without, of course, being blatant about it, like in the trademark case, right? Or your inventions or your know-how, right? So that's what we have. So getting down to the basic principles of IP rights in the workplace, who would own it? Of course, this is almost obviously. But the point here is trying to understand how the fact that the employee, who would in the first instance be the creator of the employee who would be the creator of the IP, right, asset, because, you know, in a sense, the most important asset in the company, what we say is human capital, right? Because since IP is a creation of an idea, then it is the employee who first has the idea, and or the director or the owner of the company, and then it then gets owned by the company, right? So the statutes are mindful of that, i.e. an employee-employer relationship. The intention, the default intention of both parties is that almost instantly, where you are doing work for me, as part of your employment, you create something in the course of employment, it should be owned by your employer, because if you like, that's what you were paid for, right? That's why you're here, right? In a company, right? Being paid your remuneration. It's so that what you create will be something I can not just use, I can own, right? So the law, therefore, the statute law is quick to understand that, and therefore confers an automatic transfer. That's the concept here, right? So you can see the words in the Copyright Act is deemed to be transferred, right? It's deemed to be transferred to the employer, right? After creation, immediately upon creation, right? By the employee. So similarly, you get this in the Patents Act dealing with inventions. Okay, the employer owns any invention created by the employee in the course of employment, and because the employer owns the invention, the employer is able to patent. You know, to get it from a design to a registered industrial design, you would have to register it, right? To get it from a brand, in a passing of sense, you have to register it. And then, so for copyright, of course, you don't need registration, but you can voluntarily register it with the IP office I mentioned just now. So similarly, the employer can patent the invention. And when you file the patent, you would say the owner of the patent, the applicant is the employer, but depending on the country you're applying in, you may also have to say that the inventor, you may have to name the inventor, and that's where we talk about conflict sometimes in that regard. Okay, industrial design is the same thing. Shall be treated as the employer, shall be treated as the original owner of the industrial design. Now, interestingly, there's also a case where if a design is generated by computer in circumstances such that there is no human author, okay, the person by whom the arrangements necessary for the creation of the industrial design are made should be taken to be the author. This is interesting because of what we call CAD, right? Computer-aided design. That's a particular AutoCAD, right? It's a famous software for that purpose. But I think this is where it's going. You know, in the IP world currently, there is great debate on how and who owns AI, right? Artificial intelligence created IP, right? It's a big thing at the moment. And most jurists, IP law jurists, at the moment, even in various conferences, debating the idea of is there really a human owner, right? Or do we just say the author, the person who created the software, the AI software, and then the AI software then created the IP? right? We should just let the ownership go back to the creator of the AI software. That can be challenged, especially in the social benefit context. So we are waiting for the law to catch up on that and to make some pronouncements in different parts of the world, and then in those global discussions we have. But it's an interesting point, and our ID Act has sort of touched on that point in this manner, right? Taking one side of the schools of thought. Okay, so the default position, therefore, as we have explained here, is that the employee never owns the IP, right? Because the concept is that's what you're paid for, right? This is your job. You're being remunerated as an employee to create the IP. Okay, but as you have probably noted in the legislation or the sections we mentioned just now, it is possible where this is the point here, right? Where the employee has shall we say, a better bargaining position. Okay, so I hire you because of a particular skill set or knowledge that you have, and therefore you can, as if it's a negotiated employment, as opposed to here's the letter of employment, here's the code of conduct, this applies to you, you just sign up here, no questions asked about changing any terms of this employment contract. If you had a different bargaining position, an employee possibly can negotiate a contrary position to the default position I explained just now, i.e., the employee can ask for co-ownership or even sole ownership of the IP, of course, with the company being able to reap the benefits of the IP because they would have paid something to the inventor or the creator or the author of the IP. But yet the owner retains rights, right? So if you were a textbook publisher or a book publisher, and you wanted to agree with the author, right? If the author is your employee, right, then it's possible you go into an author's agreement and you say, okay, I'll have copyright in the published edition, but you have copyright in the work, right? So in the event this agreement is over, then you could go to another publisher because you have copyright in the work as opposed to the book that has been published by the publisher, right? Or in tertiary institutions, that's a place where a university has a contract with an academician, right? Professor, an associate professor, right? And to incentivize the research, the R&D capabilities, many times, or in most cases, there is a separate IP contract between the tertiary institution and such academicians who are also doing R&D, because what they do can then be, like MIT, Massachusetts Institute of Technology. I mean, they are so well, not just endowed, right, but they also own so much IP, right, because they have these agreements with their researchers or their professors, the academicians, so that the IP is co-owned, for example, right, or even owned by them but licensed, and the university then gets the licensing power, right? But over and above those IP statutes we mentioned, we need to note that Patents Act has something more than the others, right? And this is the point. In the Patents Act, so now we're dealing with inventions, right? Not works, not brands, not industrial designs. We're dealing with inventions, which may, of course, have been a trade secret before it became IP or before it became patented, right? So in the Patents Act, there is an obligation for you have the notes here, right? So I'm not going to read through them. I'll just explain them briefly, but you can see what it says, right? So the Patents Act says that when employee has created an invention and it's part of his job spec, right? His job spec is to be in the R&D or is to create inventions, right? Or improvements to a particular, which is inventions, improvements to a particular existing product or machine, right? Is an invention, right? Improvements inventions would include improvements, right? But that's his job. Okay, he's in the R&D side, he's an engineer and so on, if it's a mechanical kind of thing or electrical kind of thing. Or, and this is the point in paragraph B, or it's outside his job spec, which means this could be the employee tinkering with what he sees, right? He's a supporting staff in the R&D department, right? And someone else is the real person working on the project, but he has ideas, right? He tinkers around, but for him to work on that idea, he uses what the company has, right? Because this is his R&D department, so he thinks that, hey, this problem, but it's not part of his job, okay? But he comes up with an idea, okay, as well to solve that problem. So in both situations, where the first one, it's employees' job specs to do so, to make the invention. But the second one is where it's not his job spec, but he has used company data, right? And what he has created or thought about is within the employer's field of activities. Okay, in both these cases, the default position on ownership still persists, right? Which means the invention will be owned by the employer automatically, as per the sections we mentioned just now. But you have an obligation, you meaning the employer, has an obligation to pay additional equitable remuneration to the employee, whether type A or type B, to the employee. You have an obligation to pay something more, right? To remunerate the employee with something more, okay? And unless you have agreed what that would be, the court will decide. I repeat, unless you have agreed or you come to an agreement or you have agreed earlier what that amount, that extra remuneration amount will be, the court will decide what that amount will be. Okay, this additional remuneration. Okay, and for the type B person, the court will look at what was the benefit, the economic value of the invention, and so on, in determining what that additional remuneration will be. For type A, that means the employee's job is the employee's job to do inventions for the employer, but the only reason why the employer has to pay something more is because that invention has given the employer an economic value much greater than the parties have reasonably foreseen. So this is the additional criterion to satisfy the obligation to pay extra remuneration to the employee, the type A, right? Employee the invention of the employee must have given the employer something much more valuable than what the parties could have reasonably foreseen. So that issue, right, actually came up recently, about 2 years ago, in UK with Unilever PLC, and the Professor Shanks was hired by Unilever to make a prototype, right? And he did something which was part of his job scope with a prototype of a particular invention, okay, and for biosensors, right, and process control. So Unilever owned it. Remember, this is not an issue of ownership. The ownership is always with the employer. The question now is, do I have to pay you more than what we agreed? By way of your salary or by way of your fees and so on? Do I have to pay you more? Okay. And then the law is the same as in UK as in here, where, okay, this was his job spec. And ordinarily speaking, you don't have to pay more than what you agreed. However, if the value was far greater than what the parties had anticipated, and economic value much greater, then you have to pay more. So the employee asked, Professor Shanks asked for more, and Unilever said no. We are paying you what we agreed. This is what we expected to get out of this invention that you had. Why should I pay you more? Then comes to going to the court to decide, was this something contemplated? Was it a value greater? And then you read here, the benefit enjoyed from the Shanks patents was far more than what the parties had thought it would be, and enjoyed by Unilever. Basically, his prototype could be used in many situations, and it covered other areas of industrial application, which wasn't contemplated when they first hired Professor Shanks. And so Professor Shanks was entitled to the additional remuneration. Okay, so that sets the tone on what rights. Oh, one more point about copyright. If you are an employee as the author, right, the first owner, the one who created the work, he would have moral rights by way of, you could not do things to the works without his consent, and there's a right to name as an author. All these rights can be waived, right? But it's there, right, on default position. So how, and of course, clearly now we move to, how does an employee protect its IP? Okay, that would be the next part of this talk. And of course, we all go into the contractual way of protecting the IP in the employment contract, right? And certainly the standard advice here is to protect, make sure that you have a tight enough agreement as to what the obligations are, what the rights are with respect to IP for the employee, okay, with the employee vis-a-vis the employer, okay? So what you get, it is common for employers to insert IP clauses. Certainly, that is certainly something you have. So go back and look for these clauses in the contract, be it in the employee's policy on IP, in the handbook, is it in the code of conduct, which is a bit unusual, it's the code of conduct, right? But it could be there, or is it employee handbook, or is it in the employment contract itself? Okay. Now, for those where there's high tech companies, or where the company realizes that the employee is in this department with a lot of IP possibilities, right, or IP generation, right? So when you're in that kind of scenario, there could be a separate IP addendum or agreement, okay, where you are more clearly setting out the respective IP rights of the company. Okay, so this is what you got to bear in mind. So now, assuming we were having a checklist to see what would be the relevant clauses you should have. So this is what you would typically have, right? You would define inventions, okay, and then you're careful about whether or not during working hours, or whether or not using company premises or resources, or whether or not recorded in material form, right? But anything you do during the course of your employment with the company, right? So even if you WFH, right, work from home, okay, you don't say because I'm working from home, but you're doing company things, right? So anything you do, right, would be inventions, okay, by you or on your behalf, right, on your behalf at any time during the course of employment. And what would be covered, right? What would be the meaning of IPR in IP rights? So you would say, and there'll be a definition later, IPRs will be defined, but all IP rights created by you on your behalf in the course of employment. So that would be employment IPR, okay? All subsisting in the employment, and then you would include employment inventions, right? Then now we define what is IPR. Patents, rights to inventions, that means inventions which haven't yet become patents, right? The know-how and so on. Copyright, trademarks, trade names, right to use domain names, rights in GetUp, goodwill, the right to sue for passing off. You recall all this, right? Rights in designs, rights in computer software, database rights, not yet fully protected. So it's by definition, we call it IPR. We don't really have a statute protecting database per se. Topography rights, which means on circuits, rights to use and preserve. This is the trade secret part, right? Right to use and preserve the confidentiality of information, and other IP rights, in each case, whether registered or unregistered, and including all applications to the relevant authorities for such rights, renewals and extension thereof. Okay, so then you will define invention, okay, and innovation, whether or not patentable or capable of registration, however created. So invention, idea, discovery, development, improvement, or innovation, okay, whether or not recorded in material form. It could be bits and pieces here and there, right? But all this would be, you can see the flow, right? Employment inventions, employment IPR, but what is IPR and what are inventions? All clearly defined. So you acknowledge that all these automatically belong to the company to the fullest extent permitted by law. Okay, so some part of the IPR, the law already says it is owned by the employer. But where you are, before that, or you are not sure yet what this will become, right? Then we say, or better, as we said just now, including drafts, right? And work in progress. Yeah. So all this would be owned by the IP, by the employee. All such IPRs will be owned by the employer. Okay. Now, I mentioned just now, the statutes already put this ownership with the employer. Okay. But assuming you had companies outside Malaysia, I wouldn't assume their IP legislation would follow ours as to this automatic transfer to the employer. Okay. And so you have this backup clause, right? We hereby assign and agree to assign, right? So where it is not automatically transferred or vested in the employer, i.e. the company, then this clause says you agree or you hereby assign. So the assignment happens, right? Or if it's not existing yet, it will be assigned. We agree to assign by way of future assignment all such IPRs to the company. And until then, you hold all this on trust for the company, right? So this is the killer clause, if you like, the killer clause that must be in the employment contract, in whichever document that embodies the employment contract. You should have these two important claims, to me, non-negotiable, unless, as I said just now, the employee has some bargaining power. So you may have to deviate from the norm here. Okay. And then, of course, you have these other supplementary clauses or complementary clauses to give full details. And then upon, in event of termination, you would give the record, surrender everything. Don't try to register, and you will keep confidential, right? Unless the company has given you consent for any such disclosure. Okay, so this would be the other additional complementary clauses. So these are the key clauses, right? Definitions, the ownership, okay, and then the complementary obligations, okay, that the company should have. So please check these clauses against what you have today, if you have responsibility for such things in your company, or seek the clarification whether you fulfill this, at least to me, minimal benchmark provisions regarding IP in your employment contract. Okay, so what happens if you fall short? You don't have those things, those kind of clauses that I mentioned earlier. Then we not a good place to be in. Any lawyer will tell you, how come it's not in your, but then we have to go back to the default position, right? And the statutes we mentioned just now are very helpful to, the automatic transfer, right? So you don't actually need the contract to do so, where you are coming under those IP statutes where there's automatic transfer to the employer, which more or less would cover most things, right? But certain things may not have been protected that way, then you would move into employment law principles. Okay, and the basic principle that comes out in cases where you fall short in the direct contractual obligation would be the duty of fidelity and good faith, right? Close to fiduciary, but not the same as fiduciary duties of directors, right? Where not to be in conflict and act in the best interest all the time. Yeah, but there is such implied terms, right? That there's loyalty, that means fidelity and good faith, right? So it cannot be making profit for himself from the company's assets, right? And he would ensure that the best interest of the company, right, is being looked after, right? The employee had that obligation. Yeah, and so you would refer to the statutes, IP legislation, and common law principles governing the IP, and then you look at the relevant employment law principles, and then you look at the case law, and then you fight the case, right? In the event of the company taking the view that its rights had been infringed by the employee with respect to IP. Okay, so if we focus a bit more on trade secrets and confidential information, then we already talked about it. It would have been in the definition that we mentioned just now: rights to use and preserve the confidentiality of information, including know-how and trade secrets. That would be in your contract if you draft the definitions in the best way possible. Yeah, other than contracts, trade secrets, as mentioned earlier, is regulated mainly through common law, the case law, right? So this is now interesting about how breaches happen. So in a 08 case, Svensson Hair Center, this was a beauty salon kind of scenario. So the employee decided to leave employment and set up or join another company, another business that was doing the same thing, which was in the hair and beauty salon business. And the allegation was that that employee had used trade secrets, okay, and this was the kind of trade secrets alleged in that case. Okay, in fact, if you read the case, it's quite interesting. There were witness statements saying that on her last day, or close to her last day, that the person had taken a box. Okay, taken a box from that particular center, the employer's place of business, and in the box there were customers' names and details, right? The treatments that the customers had, right? And the employee tried to argue that, hey, but listen, this is something anyone would know. When a person comes to the saloon, anyone would know what would be these kind of details, right? And he said, no, this was all recorded in customer cards, and you had made copies, or you were otherwise taking these customer cards, because of course what happened was the employee had been contacting the customers, okay, of the ex-employer, right, to say, come over, it's still me. I was the one servicing you. It's still me. So come over to this side, right? If you want my personal service and the skills that I had in, taking care of your hair and so on. So this was the idea here. So the law does, interesting point, right? The law does, the second line here, the law does not debar an ex-employee from making use of or drawing on the fund of knowledge and experience or skills that he had acquired while working for the employer. Okay, that would be a tantamount to depriving him of his livelihood. Okay, no, the law only imposes an employee a general duty to act in good faith, right? Such as a man of average intelligence and honesty would think proper. You realize that there's going to be this debate, right? And of course, we are in a situation where employee leaves the company, I mean, while employee is in the company, certainly all the rules bite. Okay, all the boundaries are there. You cannot be having moonlighting, secretly carrying on business and earning from the customers, from the employer's customers and so on, right? That all would be clear breach of fidelity. But we're talking about ex-employee leaving, okay? After leaving the employment, what is it he or she can do or can't do? Because the law is not trying to deprive him of his livelihood, right? Which is, in fact, encapsulated in our Contracts Act, that you can't restrain someone from exercising employment, right? And the policy behind that law is you can't deprive an employee of his livelihood after he leaves your employment by preventing him from exercising his skill and knowledge. But what did he do that you're complaining about, right? If you're saying it's just mere competing with you and you're angry about that, right? He's competing for your customers. That per se is a interesting, debatable point, right? In a sense, a gray area. When is he fairly competing? What is meant by fairly, right? And so the way the court has been looking at that specific issue, right, of ex-employees joining a competitor, right, or otherwise setting up his own business that competes with, which is because it's a similar business. What is that person barred from doing, right? And the intersection has to do most of the time, because if you have a patent granted, then of course no one else can use the patent anyway, right? If you have a trademark registered or you have an ID design, industrial designs registered, no one can use it anyway, right? So there won't be an issue of what is happening here, right? And is it okay for him to use certain knowledge that he has? And the intersection is, yes, you can earn your own, right? You can join a competitor, but you cannot use. Now, what is it you cannot use? You cannot use anything you have learned that's too broad, right? You cannot use or disclose trade secrets. And then the question comes, what is the level of trade secret here? Because remember, there's no registration of it, right? Under the IP sense. So this is what we grapple with in the courts, right? Provides a company with a competitive edge and is unknown to others, may be protected as a trade secret. Okay, and then that would be the unauthorized acquisition, right? He left the building with a box of things, right? He said it was just things, my own things. But the PW witness, plaintiff witness said, no, these were customer cards, right? The saloon center's customers' cards, right? But he says, but it's common knowledge. People see that person walk in to this saloon. So people, it's like public domain. He comes here all the time. It's a regular customer. People know they use us. So why would the name of the customer, since everyone knows this customer comes here and uses me as the service provider specifically, why would that be a trade secret? But in this case, that may not be a trade secret, that per se, but taking customers' cards in a material form. These cards belonged to the employer, the ex-employer, right? So that would say is a manner contrary to honest commercial practices, right? Then such a violation would amount to misappropriation, resulting in possible remedies, right? So that's where we have this issue. Another case. So you see, interestingly, how that principle can help you land in A or B, depending on, and I get this idea that it's like some kind of, although we're talking about the law, it's sometimes like something like he broke that moral code, There's something behind the scene I gather from this. Okay, but just remember what happened in Svensson, right? The box, someone took the box of customer cards, right? Even though people know these are the customers, or generally speaking, by way of public knowledge, right? So in Repco, this has to do with, I don't know, those of you who know spark plugs, for your car, spark plugs that has the combustion, right? So it was NGK spark plugs, the brand NGK. I remember those days in university, I had a motorbike, I had to keep changing the spark plug, and I always thought, oh, we always use NGK spark plug. This was that business, and the court said that to see whether it's a proper trade secret, we look at the nature of the employment, right? And then the nature of information received, whether the employer has stressed the confidentiality, and whether such information could be isolated from non-confidential information within the same package of information. Interesting, right? So in Repco, what you have was a employees, long-time employees, right? When you read the record, it's something like this person started as a storekeeper in the company, right? Repco company, and worked his way up to become general sales manager, right? All in the company. Yeah. And then they left. Reading the facts, they left because they found that the company was beginning to focus on other business streams, right? So they were in the sale of spark plugs, supply of spark plugs. They were resellers or distributors of the brand of spark plugs, but they began to look at other types of businesses, and the defendants say they began to pay less attention to this particular business where they came from and what they were doing to help the company. And so they found that, well, if my future is tied up with this company and they're not paying attention to this business stream, because they wanted to go to commodities and, paper market, the bond market and things like that, right? Totally different from hard products that they were selling, right? So this group of employees left and started their own business to sell the same spark plugs. But the owner of the brand, right, the Japanese owner of the brand, they were happy to use multiple distributors. So they had opportunity to actually have the same, to distribute the same brand of products, right? Yeah. And then they were, of course, going back to the customers that were part of their ex-employer. Okay. But there was no evidence of, oh, they took it's one thing to remember who the customer is. Okay, because it's public knowledge, so to speak. Everybody knows. The part of the evidence was all the sales reps had a list of customer lists. It's like all over the place, right? Customer lists as such. It's not as though these defendants were accused of, in the stealth of the night, going into the company's premises, downloading the customer database into his thumb drive, and like Pink Panther, right? And then after that, leaving the premises with the thumb drive, right? That was not proven at all, not alleged at all. This was just the defendants, so long in industry, they know who are there. They even said who buys what is out there in those trade magazines and public domain databases, right? Because they were saying, the plaintiff was saying, you are going for my customers, so you must have therefore automatically taken trade secret, because customer list is trade secret. Okay, that's an interesting point, right? How to say, if you were in the engineering department of a company, there is a workshop manual that is protected by copyright, right? You couldn't leave the place and take the manual with you and use it and replicate it for your new place of business or new place of employment. That would be protected by copyright. The manual itself, you couldn't photocopy it and use it elsewhere, right? But customer list. So in Svensson, taking the box out, wrong. Here, these customers, yes, they are part of customer list. Customer list is owned by the company, Repco. But to say they are doing something wrong when they know in their head this is the customer of the company, is it fair game for me to go for it? I didn't download and take with me a customer list, which is an official document of the company. It's just in my head, right? So, well, that's why the court said, so long as the defendant did not obtain the information and or acquired the knowledge surreptitiously, it could not be said that it constituted a trade secret. Interesting, right? I'm just wondering, are you saying that if you take it surreptitiously, then it is a trade secret? But what makes it a trade secret is not how you took it, right? But it can suggest, or why did you have to go in the middle of the night and take a thumb drive? Okay, why did you have to take a box of customer cards out with you? Those must be trade secrets because you did it surreptitiously. You know, it's like using what happened to define what happened, right? To see what happened and then define what was the wrong thing done. Okay, knowledge on the part of the defendants of the information did not constitute trade secrets which are considered proprietary rights which warranted protection by this court. Okay, so that's what happened in the Repco case, and this was also interesting. It was a Singapore case, BSL press stressing. So this was an engineer, okay, but he had joined the company with pre-existing engineering knowledge. And while in the company, of course, the company had its own manuals of doing something, right? And then after 2 years, he left the company and was involved with other companies that were competitors of his ex-employer. And then the employer said, he had visibility of my certain processes and manuals, etc. Okay. Nothing about he photocopied and took with him in a briefcase all these manuals. Nothing mentioned there about that. But he said he had knowledge of this. And so by virtue of having knowledge of it, he could not be sharing such things with his new employer, and he could not be tantamount to, he could not be working for a competitor because that would involve using the knowledge of what he had gained while in my employment. And so he should not be allowed to work for a competitor because that would necessarily mean he will use the knowledge he gained here. And so this is where a court again said, you cannot prevent from using skill and knowledge in his trade, which he has learned in the course of his employment. If he now has upskilled himself, he has upgraded his skills because he worked for you, and that is in his head. That is it. Now, when he sees a problem, if he's an engineer, when he sees a problem in his new place of work, he will use the skills that he has learned and fix the problem, right? Now, he may have learned those skills back there, using your manuals, in a sense, right? But that doesn't mean he's using the manuals or the trade secrets embodied there in his new place of work, right? Again, different from he has a copy of the manual, he's now using the manual in his new place of work to solve the problem. That didn't happen. It's just part of him now, right? And how can you stop him from using it? Okay, so this is a bit tricky. I know it's gray, but this is how the court ruled that it wasn't an infringement of the trade secret. So I mentioned just now, what really is bugging the employer actually is he did not want the employee to compete. Okay, but of course, the starting point in all these cases is, I'm not preventing someone from carrying on employment, to earn a living. But he has done this, and because Malaysian law is a absolute prohibition. Okay, that means when you read Section 28 of our Contracts Act, it says that no one can be restrained from exercising employment. Any contract that prevents an employee from exercising employment, in case law, I said, we're not talking about while he's employed. Okay, he cannot have two jobs while he's employed, right? Because there's a fidelity obligation to the employer, right? That you can't have another job moonlighting somewhere without my consent. So we're not talking about that. We're talking about post-employment contract after it's expired or terminated, right? You cannot have a contract preventing him from exercising employment. Now, it's different in common law. I mean, this is Contracts Act, right? So if you pop over to Singapore or even UK, their law, they allow reasonable restriction, okay? But that's not so for us, right? Under our Contracts Act, by our forefathers, the prohibition is absolute, okay? But this is what the employer wants, right? See, after all my years of investing in this person, etc., he goes out there, sets up his own firm and compete with me. Okay, then the next question. Setting up his own business or joining another competitor that's competing with me is one thing, right? He comes after my customers. Okay. But when you talk about that, then it becomes tricky because without Contracts Act, like I said, if you follow common law in UK, outside Malaysia, but not including India, India and us have the same Contracts Act. They allow reasonable restriction, 6 months, after employment, right? Don't work for a competitor and don't undertake a competing business, right? So that would be permitted, but not permitted in our Contracts Act. Okay, so enter the concept of confidential obligations, trade secret, to try to cover that. And that's why I mentioned just now, the cases have been struggling because this is the intersection, right? I sometimes suspect the way the court looked at it is actually it's not about trade secrets. You just don't like him competing with you, and you use trade secret as an excuse, right? That's where we have landed with. So this quite interesting case, and the judge Malik Ishak was quite blatant in saying that the employee, in this case he cited the employer, but what the employee did was amazing. If you like, the employee had sort of resigned by giving and talk to the general manager and say, oh, I have to leave now, etc. I can stay a bit more unofficially, but I want my resignation to be effective. And later it transpired that he was planning this all along, right? And he had he had been talking to customers about his impending exit, okay, while he was in employment. So this is already a breach, okay, about using company information for his own benefit, right? To say, customers, I'm leaving, okay, and I will be going somewhere else, but come with me, okay? Already trying to entice customers away. And evidence, as shown to the court, was he was also telling the customers, and you know what? I'm taking the department with me, the main team, the core team with me. So there'll be nobody here. There'll be nobody here, okay, to do the work that you're used to getting, okay, from this company, which is making of molds, right? And then he was also asking employees to leave the company and join him, okay? Now, of course, join him after he leaves, okay? And after he left, he continued doing the same thing, okay? Which means try to get customers to leave the existing, the employer, ex-employer, going after employees to join him, right? And really trying to do harm, right, to the ex-employer's business. So this is what happened in Rota Dice, right? And Justice Malik was very, some of his legal statements to me seem not to be consistent with the way Section 28 is drafted about competition. But by and large, he used the concept of trade secret to say they couldn't do what they were doing, right? And then he mixed it also with, there's a tort, which means a legal wrong without contract, the tort of interference with business, wanting to cause harm to someone's business, right? And so he used a mixture of that to say he could not do what he was doing without breaking the law, okay? And so the employee was found to be liable, right? So this is where I think this I'm not sure I would agree, from a legal point of view. In considering Section 28, there must be some measure of flexibility. The commercial reality, right, the act of the test of reasonableness. This smells of common law, which to me, Section 28 does not permit a test of reasonableness, whether or not he can be restrained after employment, restrained from competing with the ex-employer. Okay, this is a tricky part. Okay, we also have this, again, another case where the employer won in Schmidt Scientific's near Braha. This was a specific kind of equipment supplied to hospitals, right, and healthcare facilities. And what happened was the 5 defendants, they left the company after, I think, 2 to 3 years with the company. They set up another company, and then they began targeting the customers. Okay, and the facts say that there were like 5 contracts, right, that were pending, right? That means the employer had been bidding or trying to procure business with certain customers, and there were 5 potential cases happening. And they actually went for the same customers after they left employment. Hence, they were using 28, right? So you can't stop me from carrying on business, restraint of trade or restraint of employment. It's both, yeah. It's not just exercising employment, it's also from carrying on a trade or profession. Okay, you can't stop someone from carrying on a trade or profession. And that would be unlawful under Section 28. And you know, the evidence showed that they also went for the same contracts, and the prices that they used to bid for those contracts that the ex-employer was going for, they purposely bidded a low, ridiculous price, right? But that's because they knew the price that the employer had been offering to the potential customer. Okay, so again, the court was able to say, look, those were we're not saying trade secrets only refer to, look at the paragraph 2. We're not referring, the trade secrets are not limited to manufacturing processes or secret formulae, but extend to information relating to the list of names and addresses of the customers and suppliers. Okay, now, like I said, that could be somewhat, if that was all that happened, well, did you take out a box? Did you download a thumb drive, or was this just people in your head? Okay, interesting. But then more else. There was more to that, more to it. There were specific questions sent to the customers, cost prices, specific needs and requirements of the customers, and status of the ongoing negotiations, right? I mean, these were what they used after they left the company, right? And then it was not the plaintiff's case to restrain the defendants from entering the same trade, but to restrain them from using confidential information that they had gained. So this is the interesting part about the intersection in the use of trade secrets. I hope these cases, you know, the Swenson case, the hair, the beauty salon, the NG Spark Plug case, the press engineering case, the DICE case, the most, right? And this Smith case, these 5 cases gives you some indication how to be careful, right? If assuming you went for an employee post-termination or expiry of the contract. Now, the last part I just wanted to share about how is it you manage remote working in IP. Like I said, the IP remains the IP, right? Whether it was WFO working from office or WFH working from home, it remains IP. Both scenarios do not change the nature of ownership and the obligations. Okay, the point is, when you're remotely working, you have to be careful in the practical sense, okay? Because you don't have perhaps the usual ring fence and protection found within the confines of the office space. So that's the point, right? So you of course have to do things to allow access and communication, right? Where if you were predominantly securing communications because everyone was in the same working place, that's one thing. But when you allow working from home, then you must allow access from a computer. Now it's different if you are, big audit firms or banks where I give you a laptop, right? And now you must only use this laptop for the company work and not for anything else. And everything is secure, okay, from an IT point of view. Not many companies can afford that kind of high level of security. So you can say, okay, we open Outlook access. You can access it from your own personal laptop, and then this is where WFH you get problems about. I can't reply to email now because my son is using the computer for his online lessons, right? Okay, we have to live with all that during this WFH, which we thankfully hope, prayerfully hope that it will end soon, right? So this kind of things is actually practical risks which you have to go into, right? And very much cybersecurity and IT comes into play. And of course, the attendant costs that go with it. And of course, it becomes more cumbersome to work from home. Many of us have experienced it as well. Okay. So the teamwork in the IT sense, do you want to use VPN, okay, for securing information or the database, right, that is there? Do you want to ensure that they are, well, legal and compliance, then begin to check on what would be the way to deal with this aspects of risk, right? Do you need to put further SOPs in place and make employees sign off or be aware of what they can or can't do, because now more risks have emerged in the remote environment? I'm sure many of you have already done this process. I mean, we've been like this for the last 1.5 years, right? So you must have arrived at some landing by now, but this is just a reminder about what could happen. Yeah. Now, from the by way of documentation, if you don't encrypt, for example, then there's always the risk there, right? Whereas if they were in the office, possibly you could track leakages. Now you could not. So possibly what you need to do is heighten the awareness of employees on the contractual documentation, right? And this is where we have, and this is what you would highlight, right, in the training or in the reminder to employees that not that you're intentionally but now the safeguards we had when you were working in office are no longer there when you're working from home. So remember these things, right? Don't leave the computer on, right? Because you don't know who is visiting you and who can watch and see the screen and so on. So you heighten this in communicating to your staff working from home. So I will end with this particular case, which was pretty interesting. And this was even this is a 2004 case. And this is an IT company, of course, Computer Associates, it was Quest Software. So what happened was they already allowed remote working, right? So there were a group of employees who were working remotely, okay? And then there was some, mergers and acquisitions going on. So in the midst of all this set of employees who were working on a particular code, a program code in computer, DB2 they call it, database program. They were developing the code for Computer Associates, and then they left the company because of the merger or acquisition exercise, and they joined a competitor, which is Quest. Okay, so interestingly, when they joined Quest, this group of people, they worked for Quest for the same kind of DB2 product. Okay. And then lo and behold, Quest was able to release a DB2 program, and which competed with CA's, Computer Associates DB2 program. Okay, and then when Computer Associates analyzed the code that was in Quest's DB2 program, they found similar codes in the program, right? That this group of employees had been doing for Computer Associates while they were CA's employees. So then, now this is where you have the overlap between IP, right, and employee breach. So CA sued Quest and said, you are infringing copyright because your code is the same as mine, right? But copyright means I copied the code from you. If I developed it myself, you can't say that I copied from you. Then CA says, you didn't develop by yourself. You copied me because these same people were working for you, right? And it's so like, what's the probability that they came up with the code by themselves? This was the code they built for me when they were working for me. So you copied me. I'm suing you for copyright infringement, right? I'm not suing you for breach of confidential information, right? But I'm suing you for copyright infringement, even though they may have tried as well for confidential information. And then for the employees, they sued them for breach of confidential information for using the code that you did for me and using it for your new employer. Okay, and one of the defenses used by the employees was, I didn't know that this is, secret, trade secret, right? And you didn't tell me because I wasn't in an office where I have, visibility of all your notices and all that. I was working at home, right? So I didn't know these were all part of my trade secret obligation. And to this, CA successfully showed to the court that no, the policies were in manuals, right? And it prevented outsiders from gaining knowledge. And the fact that they were in the manuals must be deemed to have been known by the employees, even if though they worked from home. So in a sense, fortunately, there was like no particular rule to, the idea was to be reasonable, right? Reasonable in telling employees that you have to be careful and this is still trade secrets, and having it in the manuals were considered sufficient. Okay, Quest on their part said, listen, I have a very strict policy for incoming employees that they cannot use the trade secret or confidential information of their previous employers. So please don't come after me for breach of receiving confidential information intentionally, right? Copyright infringement, let's fight, okay? But not for this, because my own policy is to tell incoming employees not to use the confidential information of their ex-employees. So this is an interesting case to show how it came together. Okay, so I would end here and let's see now, and hand back to Amira in case there are any Q&As.
Thanks so much, Keat. Yes, actually, there is a question by Alvin from EdXL. The question is, what happens to co-ownership of the IP asset, like copyright, between the employer and such employee in the event that the employment relationship is terminated?
Thank you, Alvin, for the question. So I'm not trying to be pedantic, but we follow what the contract says, okay? So there's no way you should just say, we will both co-own this work. Okay, we will both co-own the copyright in this work, right? Now, if you just leave the clause like that, right, then Copyright Act says, oh, when copyright is co-owned, there are certain consequences. Anything earned by one party must be shared with the other party as well from that copyright work. You see what I mean? So you don't, subject to agreement to the contrary, of course. So if you just say we shall co-own the work you do, which is fine. There's nothing wrong with agreeing that way. It means the employer recognizes the value of the employee, or maybe that's the terms of the employee puts before he allows himself to be employed by an employer. Okay, what you must do thereafter is spell out what co-ownership means. And subject to the contrary, co-ownership will, subject to the contrary in the contract, co-ownership will always outlast the employment, because ownership is always permanent to you, right? And absolute to you as co-ownership, right? You're not the sole owner, but you own it absolutely, in that sense of both of you own the same thing absolutely. It's something like my wife and I are co-owner of this piece of land, this house. I don't have a boundary saying this is your half, this is my half, right? Yeah, we are what we call co-proprietors, having shares in the land, which is absolute shares and without boundary. So you should spell out, and you probably would have clauses to say something like, while you are in our employment, the meaning of co-ownership is like this. Okay, example, you can't take the product and sell by yourself. Everything must be through the company. Okay, you could say that in the co-ownership clauses. Then thereafter, should you leave the company, co-ownership, if you want to say co-ownership ends, fine, right? Which is unusual because the employee won't have agreed to that, because he, first of all, got his bargaining right to get co-ownership. So he probably say, we carry on with co-ownership. And you probably want to say, okay, after you leave employment, I own it, you own it, you do what you want with the product. I will do what I want. I will not account to you for my profits. You don't have to account to me for your profits. Okay, so we can both do whatever we want. And so from, a product is never static or stagnant. It goes on, right? It goes on. So the new versions, whatever, will be owned by the person who, the party, the co-owner who developed the improvements, right? And without any regard to the other co-owner, because the contract says we would each go our separate ways and do whatever we want without accounting to the other. So my main point is, don't leave it hanging, right? We shall both co-own, full stop, that's it, right? You should then specify the scenarios on the meaning and implications of co-ownership. Hope that deals with your question, Alvin. Thank you.
Thank you very much, Phye Keat. Alvin, does it? Yes, it's very clear. He appreciates it. All right. Thank you so much, Phye Keat. I don't see any other questions, but if anyone has any questions, we do have 4 minutes. Okay, I don't see anyone typing, but if anyone does have any questions through the rest of the day, if we think of it along the way, would you be okay if I contacted you, Phye Keat, with the questions?
Yes, sure. Be happy to. Yeah.
And then we can do that. So on that note, thank you so much for the time, Phye Keat, and the very interesting, enlightening as well, cases and the clarification of IP. I will then say thank you very much, and we will take a break for lunch, everyone, and we will commence back here at 2:00 for the next session. Thanks so much, Phye Keat, once again.
Thank you. Bye.
Thank you.